Is it on the docket today?
It was on the docket today, yes.
All right, what's the name?
I think it was Crystal Avalos. Yeah. Yeah. The
Okay.
2019 case, yeah.
Okay, so when can you set up the Zoom, Norma?
I have to call Guadalupe for another client on Monday, so I can go on Monday.
Okay. And I could zoom in. I guess
Yes.
the only question I would be, because it's gonna, how do I do the paperwork with her?
Oh, they'll send it to you through email like we did it before Adobe.
Okay, okay.
And Norma, on that one, if you can make sure that
No
when they
worries.
do the paperwork, they do the consent to appear by Zoom.
Yes, ma'am.
All right,
March, yeah.
all right, so we'll set it up for Monday.
Okay, super. I'll either be in person or. Zoom. Do you know what?
Vashawn, on page 5,
I'll have to.
Avalos is gonna come back on Monday. It's gonna be by Zoom. She's in another county. Sorry?
It is the Bexar.
13th.
13th.
Okay, yeah. Yeah. I can't find it.
Oh, it's on page,
No. I'm sorry. The 13th.
yes, the 13th.
So I just, I asked my hairdresser to send me.
Oh, okay.
It's like, it's kind of similar to a Brazilian blowout, but it's not.
All right, who's up?
Page one. What was it about the non-repeat? Check.
Hazar Johnson.
Rat. Trash. It's not my fault. It's not my fault. Did you make a call in your paper? No, I. Go over there and look for trash. No.
They were happy.
Well, that's.
Hello, and counsel, you're on this side. Hello, Mr. Johnson. What happened to your head?
Fell out the bunk.
Uh-huh. All right, so what are we here for today?
Judge, I'm asking for a reset in this matter. I've had 6 days with the discovery, which is voluminous. And moreover, the state has just now given us an offer, which I've advised my client not to take. And we're going to have to do some more discussion and discovery in this case. So I'm asking for a reset, Judge.
All right, Ms. Ferguson. I need a 30-day reset, and this will be for a plea deadline date.
November 12th?
That's fine.
All right, so we'll be back on November 12th. On that day, you need to let me know whether or not you reached an agreement. If you have not, then your next setting is going to be a jury trial. All right, thank you.
Thank you, Your Honor. May I be
You're welcome.
excused?
Yes. All right, who else is ready?
We're ready to start it down. It's Michael Sewell.
Michael Sewell.
So since I discovered I have curly hair, I have taken an interest in curl pattern
See, let me
and
just tell
products.
you, we are saving Bashan, right?
Well, it sounds too late. Well, not her aunt though. The products make all the difference for me.
It does, it does. And you know, people who have curly hair don't want curly hair. People who have straight hair want curly hair.
Yes,
I just decided in my time on the planet, let it do.
let it do. Yes, I understand that.
All right, the court is calling 2025 CR 007326 State versus Michael David Sewell. Can I have parties announced?
Lauren Espinosa for the state.
Lauren left in for Mr. Sewell.
And are you Mr. Sewell?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
We did, Your Honor.
The court will find that the state is in compliance with discovery. All right. And is there any applications?
No applications.
All right. Mr. Sewell, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are we proceeding on the indictment as presented?
No, Your Honor, if you would allow, the state would move to orally amend the indictment. It is alleged as the defendant's name is David Michael Sewell, but I believe his proper order is Michael David.
Any objection?
No objections to that. That's correct.
Mr. Sewell?
Yes, ma'am.
All right. We also need to, how do you spell your last name?
SEWELL.
All right.
So we may need it. for-
Then also, Your Honor, may we add another T after the W in the last name?
No objections.
All right. Any objection to the court changing the name and the paperwork?
No, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah.
Yes.
Yeah.
Yes?
Yeah.
Well, yes, ma'am. Yes, ma'am.
Okay.
I was thinking, I thought I went no to contender.
She hasn't asked you.
Okay.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes,
Did you understand by entering this plea, you're giving up those rights?
yes,
And did you intend to do that and enter into a plea in this case?
yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you
Oh.
believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Sewell, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Oh, I'm so sorry. I'm not supposed to ask you whether or not you're a citizen. Did you understand by entering into this plea? If the court follows your agreement, if you are not a U.S. citizen, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 60 days in the Bexar County Jail under 1244, and there's $1,000 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
Yes, Your Honor. State offer states exhibit 1 and all attachments.
No objections, Your
All
Honor.
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just ask the court follow the plea agreement.
All right. So the court will find you guilty. The court will sentence you to 60 days in the Bexar County Jail under 1244. There's $1,000 fine, time and money will run concurrently. And the court will give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honor.
I'll question your counsel fine. How long was that?
The money and fine run together.
Okay.
All right.
All right.
Do you have questions or not?
No, I'm okay.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. It's obvious that you have a drug problem, right? If you do not solve that problem, one or two things are going to end up happening. First thing, you're going to continue to get arrested, and you're going to end up spending a majority of your life in jail or either in prison. Or number two, you're going to end up getting a hold of some bad drugs, or who knows, maybe the drugs are just fine. But that one time, there may be some issues. And the last time you use may be the last time you use, and then somebody's going to have to identify your body. Do you understand?
Yes.
Now, when you're released from the Bexar County Jail, if you cannot find a place that can help you with sober living or help you with any drug issues you may have, if I'm still here, you come back here and I'll pick up the phone and call somebody to help you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you.
May we be excused?
Yes.
Thank you. Nice seeing
Have a good
you.
one.
Johnson,
Who's next?
Sergio Martinez, page 6.
Oh, no, I was gonna ask.
All right, Sergio Martinez.
Hello, Your Honor.
Hello, how are you doing?
You're doing wonderful. Thank you.
Yeah.
It's good to see you.
You too. Let me see, what do I have here? All right, so where are we on discovery?
The Well, on the motion to revoke, Your Honor,
Oh, this is is this the motion to revoke?
it's maybe 3 new cases that all arise from the same incident.
Mhm.
And those are alleged on an amended motion to revoke of a burglary of a habitation case that he's on for. What we would like to do is recall it for a disposition on Monday,
Okay.
and it should work out on that day.
Oh, I don't need it now. Thank you. All right, so we're gonna come back on October 13th. All right, thank you.
Thank you, Your Honor.
You're welcome. All right, who's next? All right, is there an attorney who's present, who's ready?
I don't know if she's on Zoom.
You're ready?
Yes,
Yes,
Michael Mora, Judge, you appointed me this morning.
yes. If you'll come forward.
Tomorrow.
Hello. All right, so this is the new attorney who's been appointed to represent you. The previous attorney was not on the first degree will, so that's why you have this new attorney.
Okay.
So were you able to exchange information with him? Contact information? All right. So are you asking for 30 days?
Please, Judge.
All right, I need a reset for 30 days.
November 12th.
All right, we'll set it for November 12th for discovery. That's just to make sure that your attorney has all of the information that he's entitled to have. And then state on that date, you need to be prepared to tender an offer.
Yes, ma'am.
All right, once you sign the reset form, you excuse. Thank you for dressing appropriately for
Thank you.
work.
Thank you, Judge.
Thank you. Oh, Kelly,
Yes, sir.
would you come forward for a second?
Phone down, ma'am.
All right, any other attorney who's present and ready? Bud Bashan, that was a terrifying nightmare.
Here's a copy of the thing.
I think that.
Yeah.
Yeah, just. Which one?
Yes.
I think you may have the physical file for Joshua. I may I see it. Thank you. Thank you.
Any other attorney who's present and ready?
Anybody on Zoom, Judge?
No. Yes. What case?
James Ross.
Is that a motion to revoke?
He had a new number one, and so we set over today to see if he would get indicted, so we can kind of get some direction on what to do. It looks like it has been indicted. I'm about to give him a copy of this indictment right now.
If you all could give me the motion to revoke on that. Thank you. Hi. Yes, you guys made it back?
Yes, I got some information.
Good afternoon.
How are you?
Hi.
We're gonna go ahead and take him.
Help me, Obi-Wan Kenobi, you're my only hope. Oh,
So Daniel took a look at it. He talked to me a little bit too. Unfortunately, he's still caught up with
yes.
whatever he's doing. But he texted to me, he goes, take him, we're good to go.
If you guys want, why don't you just come and we can be the comment of reproductive of this, if you could come with that. Perfect. Yes, we are gonna take them. You're welcome. Sounds good.
I'll come back, Judge.
Okay,
Thank you so much.
thank you, thank you. All right, anyone else ready? Okay. And no one else is still logged in. All right, Ms. Vasquez, who do you have?
Is it Wilson?
Isaac Wilson. If you'll come down, please. All right, what is happening with this case?
Tell me to get the
Just
camera.
1 second.
You want me to go first, Judge?
Yes.
So as of the last setting, we were waiting on a video from Via. As of this morning, state did not have it, but during lunch hour, we secured it. So I have a copy for defense counsel that I can tender to the fourth floor window.
Okay. All right, and the
Judge, can you hear
via,
me?
Like the Via
Yes.
survey.
all right, the via,
Okay.
via surveillance is the only thing that you're
Yes.
waiting on? And were you able to tender an offer?
Yes.
Okay.
I am so sorry, Judge. I missed everything. My audio wasn't working.
All right, the state has the via surveillance. They'll have it at the window available for you.
Oh, okay. Yes, that was the issue this morning. They did not have that.
Okay. So your attorney was just waiting for that to you. All right, Ms. Ferguson, if you're, how old are you, sir?
36.
All right, Ms. Ferguson, if you'll recall this in 3 weeks for a plea deadline date, please.
Judge, if I could request a reduction on bond while he's pending the next hearing.
All right, has a motion been filed?
I will file it right now, Judge.
All right, once you file the motion, just ask Ms. Ferguson to put it on the docket and I'll hear it.
Okay, thank you.
All right, October 30th is going to be your plea deadline date. At that time, you'll need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, your next setting will be a jury trial date.
Okay.
All right, thank you. And your attorney
Thank
will
you,
file
Judge.
for a bond reduction and we'll have you brought back over.
All right,
All right, thank you.
thank you.
Thank you, counsel.
Thank you. Thank you, Judge.
Anyone else ready?
No. Yeah, ready, but just.
All right, as soon as he's ready, we'll take it up. Yeah.
Yes.
All right, Timothy Hernandez. All right, the court is calling 2023 CR 0469 State versus Timothy Hernandez. Can I have parties announced?
Lauren Espinosa for the state.
Adam Thurs for the defendant, Your Honor.
And are you Timothy Hernandez?
Yes, ma'am.
All right, defense has filed a motion to set bond, and is this a motion to revoke as well?
No, Your Honor, it's only a motion to set a bond.
No, I mean,
Uh,
is he on probation?
Yes, Your Honor, it's an MTR, Your Honor.
All right, can I see the MTR, please? And it's on Timothy Hernandez.
Thank you.
Thank you so much. All right, so the defendant is on deferred adjudication, so he's entitled to a bond. And have you all discussed the motion to revoke?
I do not believe so.
No, Your
All
Honor.
right, so if y'all would discuss that and then come back up and I'll take up your motion to set bond.
Yes, Your Honor, thank you, Your
All
Honor.
right, thank you. Yes. All right, so the motion to revoke, is that going to end up being contested?
Yes, Your Honor.
It's that next Thursday?
Yeah, the NPR was set up.
All right, thank you.
Your Honor, I'm not the attorney record for the MTR, I'm the new number one. I'm only the attorney record for the
The
The-
motion to revoke?
motion rule.
All right, so here's the thing. This is your attorney for the motion to revoke. According to the allegations in the motion to revoke, there's only one allegation in the motion to revoke, and that's a new number one. So this attorney is going to be handling that motion to revoke. And since it's contested, it's going to be contested with regards to the new number one. Do you understand?
Yeah.
All right, so you're on deferred adjudication. Do you understand that? The state is alleging that you violated your deferred adjudication. And this number one, is that a misdemeanor or is that a felony? The allegation?
It's a state jail felony, Your Honor.
No, I mean the new number one within the motion.
Yes, state jail felony.
So is the charge?
So the charge is a driving while intoxicated with a child under 15 allegedly.
All right, so what that means is whether he represents you on the new number one or not, that's not an issue for the court because you're on deferred adjudication. He is stating that he is your attorney on the deferred adjudication, so he handles that entire motion. Do you understand? And you're set for a contested hearing on Thursday. Do you understand?
Yes, ma'am.
All right, so with regards to the motion to set bond, have you all come to an agreement?
Yes, Your Honor, I believe our agreement is for $10,000 bond.
That's correct, Your Honor.
All right, Mr. Hernandez, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Timothy Hernandez.
All right. In the past, have you ever had any type of mental health issues?
No.
Have you ever been on any type of medication for mental health issues?
Not terribly, no.
All right, so the person who's in the back, let me ask you something. We're off the record. Have you been sworn in to testify? So your answers are not his answers. Do you understand? Okay.
So she's here for somebody else in the box.
Well,
No, she's a wife.
she's, my next question for you is, have you ever used any type of drugs in the past?
Yeah,
And what would that be?
just marijuana.
All right, this is what the court is gonna do. The court is gonna set your bond at $10,000. There's to be no driving. Any other conditions requested?
Random UAs, or I'm sorry, he said, I'm sorry.
Yeah. Okay. And there's to be 15 sober meetings in 15 days. All right, is there anything else?
No, Your Honor.
All right, we'll see you on Thursday, and Thursday will be your contested hearing.
All right, thank you, Your Honor. Thank you, Your Honor. May I speak on?
Norma, he needs a reset. Norma, he needs a reset.
I just told them.
Thank you.
Thank you, Your Honor.
You're welcome. All right, Deshaun, that's October 16th contested. All right, just ready for that. Thank you. And on Mr. Hatch, when is that coming back? Do you have a date?
No.
Ah, okay, so there, oh, here's Herman, hi.
Thank you.
You're welcome. When do you think he will be
I can
officially?
get him in next week. I just need to coordinate with Malik and he just needs to be on probation.
Okay,
So that's the only two things I'm looking at.
all right, so let me see the file on Hatch, please. Malik Hatch. Oh, you're welcome. You know.
Shed tears.
All right, so is he, then they're saying that he needs to be placed on probation? So,
Yeah, I'm not
So-
sure what.
let's do that. And if we get that done today, they'll be able to have him in the program next week. So if you will state, are you on Hatch? All right, so my understanding, he's being accepted into Veterans Treatment Court. And they're willing to get him into the program next week. But we need to go ahead and do sentencing today.
Okay.
So if you could draw up the paperwork and then we'll take care of it today. And then I'll put as part of the orders, my not general, but specific conditions to him. And one of those conditions will be a referral to Veterans Treatment Court. And if he doesn't show up, so
He sounds like we just talked. He sounds like he's ready to go. So
Okay,
we'll
all
get it
right,
going.
so just go over the paperwork and then Ms. Abrams will give me the referral for you all. And
Perfect.
we'll go from there.
I'll write it out.
Of
Thank you.
course. All right, are the parties ready on Audrey Jessica Bash?
Yes, Your Honor.
Ms. Bash?
Yes, Your Honor, I'm grabbing some certificates of completion.
Oh, sure.
Take pictures, copies of these.
Okay,
uh,
well, do you want to go to the back and make copies?
if I can make copies of these.
Sure,
And then, but we could do that, let me do that real quick.
okay, sure. And Ashley, have you all figured out how to do that or?
Yes, we're gonna.
Sure. Oh, and the other thing I didn't think of. All right, Audrey Jessica Bash. Thank you. Hello.
Hello.
Court is calling 2025 CR 008-991 State versus Audrey Jessica Bash. Can I have parties announced for the record?
Joseph Stateson for Audrey Bash, and Your Honor, if I may, we are here for her to enter a plea on the motion to revoke probation, and there's another one offense that she intends to plead on. And just so the court's aware, we're gonna ask for a PSI and for sentencing to be the same day as the MTR PSI, the same date to handle both sentencing.
Yes. All right, counsel, and this cause number, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
And your Ms. Bash? Did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes.
And I also have an application for community supervision. Did you review that as well?
Yes, I did.
Did you review the true bill of indictment with your attorney?
Yes,
Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Bash, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
You're charged with unlawfully carrying a weapon with a felony conviction. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 6 years in the prison and up to I'm sorry. Did you understand? I'm reading the plea bargain agreement. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
We've discussed that. Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Bash, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yeah.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied re-entry, and denied naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication or community supervision. This will run concurrent with 2024 CR 2272. The state will take in consideration 2025 CR 008992. Did you understand that to be the plea?
I do.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I do.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you're requesting a PSI and TAP evaluation, that
Yes,
will be
Your Honor.
12 weeks.
We're hoping that something could be scheduled sooner, and if something else drops off, if an inmate is sick in the hospital and it bumps her up, we would hope to come back before on an earlier setting.
All right.
And she did have a TAP evaluation earlier, but I don't know if that's been expired or not.
All right, Norma, I need a date, PSI and TAP evaluation. Let's put it down for 6 weeks. Let's see what we can do. All right, we'll say yes.
Hopefully November 20th and not too late.
All right.
Thank you, Judge.
You're welcome. So we're going to move on to 2024 CR 2272. Did you have a chance to review the motion to revoke community supervision with your attorney? Did you understand it? Are you the same Audrey Bash who was placed on community supervision in 2024 CR 2272 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on September 19, 2024 for a period of 5 years? Is that you? All right, state.
Violated condition number 1, on or about the 5th day of May, 2025 in Bexar County, Texas, the defendant Audrey J. Bash committed the offense of unlawful carrying of a weapon with felony conviction in violation of condition number 1.
How do you plead to that? True or not true?
True.
State.
We would waive all others.
Any objections to the waivers?
None.
Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, sentence you up to 10 years in the prison?
I do.
Knowing that, do you still wish to plead true to violation of condition number one? Court will find violation of condition number one true. This will be recalled on November 20th. All right, is there anything else?
Nothing further at this time.
All right, thank you.
Thank you.
Thank you, Judge.
You're welcome.
On off the record, I do have certificates that she may be taking some more classes, not to include in the file, but on November 20th, I intend to just have you review those.
Sure. All right, thank you. Oh, just give me 1 second. I just need to put this in the system. Yes. Counsel, Leland, yes.
Judge, Mr. Ross, has the MTR as a result of this new case. And so we sent it over to today to see if he got indicted. He got indicted. And so we're just asking for the quickest trial date possible. If you need to send us down to impact, we're okay with that. Mr. Ross is just indicating that he wants to have his day in court and get this case resolved really quickly. So whatever way we can get that done, we'd appreciate it.
What, do you want to hear the motion to revoke?
Oh, well, no, we wanted it to carry with trial, just trying to get a really quick trial date. We can go to trial within, say, 2 to 3 weeks, we'd be good with that. If that's possible. I don't know.
That's probably not gonna be possible because we have murder cases that have been set, capital murder cases that have been set. State, when do you all anticipate being ready? I could place it on the date with other cases and see what happens to those other cases, but they already have murder cases set.
Well, any accommodations the court can make, we're open to. And again, if you want to kick us out the impact court, we're good with that. Whatever.
We don't have,
We don't have that. Okay.
not with a jury trial.
Yeah, whatever the court thinks is, can get us there, we're open to.
If y'all want to confer with Ms. Ferguson, but I will tell you this, the motion to revoke will be heard quickly.
Okay.
So. And are you all, because today is the contested hearing for the motion to revoke. Are you all ready on that?
So we were prepared to prove up the technicals,
Okay.
but regarding the probation officer, we were waiting to see what was gonna happen to see if she comes down, so I kind of been. Also, I guess, in theory I was, but the probation officers aren't here, so no.
Okay, so this is on Ross' case, the probation officer is out of county?
Well, she's not out of county, she's in town, but I haven't told her to come down there because it's in an office that takes an hour or so to get here.
Okay. So this is what we'll do. Norma,
Yes, ma'am.
set this hearing for contested. Can we do it the week of October 20th? Because we have a jury trial next week, correct?
Yes, ma'am.
All right, so if we can do it for the week of October 20th. And are we able to do it? Would Monday be better?
Yeah, Monday would be better.
All right,
I have
October,
I have a trial date that day in Hayes County.
okay.
And so, I don't think he's gonna show up, but if he
Okay.
does.
All right, Ms. Ferguson, are we able to do it October 27th?
Thank
you. Okay, so we'll do, Mr. Ross, your hearing will be set for a contested hearing, agreed date for October 27th. And counsel, Do you want the probation officer here in person, or are you okay for them to appear by Zoom?
Well, I was going, the one thing I wanted to point out was the technicals are stuff that, just for context, like when you get violated, you bring the whole kitchen sink, everything you've ever done. But most of that stuff he was still in the progress of doing is really just a new number one. I think it was like a parenting class or something like that. Maybe he didn't take, he didn't, maybe he failed to report one time. I think he was actually in jail when that happened because he got arrested. So Mr. Ross is saying he would like to speak with the court.
Okay, so just 1 second. So that's the contested hearing is gonna be set for October 27th. And then Norma, I need a jury trial date on that new case in state and defense, if you'll confer.
We'll take whatever you want. We'll take it.
Okay. All right, so December 9th. And Mr. Ross, there was something you wanted to say? Oh, no, no, no. See, here's the thing. You're not allowed to talk about what you've completed until we actually have a hearing on it. Then those are things that for your attorney to bring up. Oh, no, no problem.
We'll be back.
All right, thank you. And on the new case, if you all can sign an acknowledgement of discovery for the court. All right, anyone else ready? Okay, and is that the last? Oh, we have Daniel Flores. All right, thank you. Okay.
I told him to zoom in, but he was asking.
No. I mean, we can't recall for tomorrow.
Yes.
I can see. Now I can see.
He's ready.
Now I can see all the parties. All right, guys, whenever you're ready with your paperwork, just let me know. Now, okay, listen clearly to me, people. What starts with E, ends with E, but only has one letter?
I.
You're only gonna kick yourselves. An envelope.
Letters in there.
Okay, no.
Docket matter.
Mhm.
There's a current MTR,
Mhm.
the basis of which is a new number one. That new number one has been dismissed.
Okay.
I spoke with Miss Albin about it. The state said they would be comfortable withdrawing it.
Okay.
So I wanted to see Judge, because she is in custody, if, and I'm gonna be out next week, if the court could entertain the withdrawing of the MTR due to the dismissal of the new number one.
All right. Are you?
Deshaun will have to do the withdrawal.
Withdraw.
Yes.
Okay, okay, cool.
And are there any requests for any conditions with the withdrawal?
If the court would entertain them, I could come up with them. I just didn't know.
Well, I
if we
mean,
would
no,
do
if,
that.
if you want to speak to the defense, if there's something that can be done to help her or something that she needs, if you all confer with Ms.
Sure,
Abrams
sure.
on that and see, because there may not be a reason, because it's been dismissed, so,
Dismissed, exactly right.
yes.
Okay, yes, Your Honor. Go ahead, yeah.
Yeah, and just let me know, but I'll sign the withdrawal. And also, counsel, if you can give me the cause number for the allegation that's in the motion, so I can put it in the system, and if you all have a dismissal or somebody, or if, was that no build or?
Your Honor, it wasn't a no-go.
All right, and has it already been signed? Yes,
Oh, yes, it's been closed.
okay.
Your Honor, answer your question. I have that cause number. It's the dismissed case 2025 EF 31282.
All right, thank you. I just want to make sure it's in the system, so it won't pop up.
Did you still need Becky or you can see him at eight?
Oh, no, his
Four, right?
attorney is supposed to be back here at 4. And Renee, on that case, it's important that that you find out whether or not she's already presented a valid driver's license and proof of insurance. Because she's not supposed to be driving until that's presented. All right, Malik Hatch. Court is calling 2025 CR 002-556. State versus Malik Hatch. Can I have parties announced?
Christine Dolphin Hernandez for the defense. And then
Okay.
we do have a victim impact this case.
All right. And are you Mr. Hatch?
Yes, sir.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hatch, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hatch, did you review the court admonishments with your attorney? Did you understand it
Yes, sir.
and sign it in all the appropriate places?
Yes, sir.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, sir.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
absolutely, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Hatch, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, no,
Anyone promised you anything other than the plea?
no, no.
Are you satisfied with the way you've been represented?
Absolutely.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at $1,000 fine. If the court finds that a weapon was involved, then the court will enter in an affirmative finding of a deadly weapon. The state recommends deferred adjudication. This will run concurrent with 2024 CC 737673. There's to be restitution of $1,407.24 to the complainant in 2024 CC 737673. Did you understand that to be your plea?
Yes, sir.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
Your Honor.
Any pretrial motions that have been heard and ruled upon?
No, Your Honor.
No problem. Outside the agreement, the state is recommending that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with the complainant. Did you understand that? Those are recommendations from the state, and the court does not have to follow those recommendations.
Yes, sir. I have a question.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers states exhibit 1 and all attachment.
Any objection?
No objection, Your Honor.
Mr. Hatch, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Since Mr. Hatch has been out on bond, Your Honor, he has taken full responsibility of his own actions. He is seeking treatment through the VA hospital. And at this time, we were also seeking entry into the Veterans Treatment Court program. He has been evaluated, as you know, Your Honor, and preliminarily accepted into that program. He is looking forward to earning his second chance, Your Honor. He understands that his actions were uncalled for on that day, but that he has some health issues that he's been addressing to make sure that nothing like that happens again.
All right, Steve, have you had a chance to speak with the complainants?
Yes, Your Honor, they're in different state.
Okay. All right, I tell people this all the time. Accidents are just accidents. That's why people have insurance. It shouldn't get to the point where people are fighting after an accident occurred. It's everybody gets out of the vehicle, everybody exchanges insurance information and, you know, their driver's license. And everything is not an accident where people are in the middle of the road impeding traffic. You're not going to get millions of dollars, but when people are involved in accidents, you can't get angry at other people. It's just not done.
Yes, sir.
Right. And I understand that you were in the military.
Yes, Your Honor.
Yes, sir.
And what branch?
Army.
Okay. All right, this is what the court is going to do. There's $1,000 fine. That will be probated. Are you currently employed or no? Is that due to health issues?
It's due to him seeking treatment and having an aggressive treatment schedule, but also this case has kind of held him back. He's also in school right now, Your Honor, and will be finishing his business in his management program at the end of the year,
January.
January. Yes.
Okay.
I know that the complainant is present and would like to say some words today, Your Honor, and I don't want to overstep. The aggression was definitely on both sides that day. Mr. Hatch felt threatened and he felt triggered. Not saying he was rational, but he felt triggered by some words that were used that were racially motivated, and he should have reacted differently, but the complainant is not completely innocent in this.
All right, there's $1,000 fine. It'll be probated. You to provide proof of employment or full-time enrollment in school within 45 days. There's to be no employment as a home healthcare provider with minors. Regular reporting by Zoom or in person, regular random UAs. This will run concurrent with 2024 CC 737673. There's to be restitution in 2024 CC 737673. And is that case being taken in consideration or no?
No, Your Honor, they are to, or yes.
All right, so I know they're going to ask for restitution there. There will not be double restitution, but the total amount of restitution will be $1,407.24. So if he pays it in misdemeanor court, then
It'll count for.
oh, Bashan is like, no. So how should we do this, Miss Abram?
Either on this or on that one. It needs to be on either one.
We would prefer to be on this one.
All right, so then there will be no restitution entered under cause number 2024 CC 737673. However, there is to be restitution in the amount of $1,407.24 to Michelle Morales. There's an affirmative finding of deadly weapon. There's to be no contact with Michael Oliver and Michelle Morales. There's to be 200 hours of community service restitution. 6 years deferred adjudication. And referral to referral to Veterans Treatment Court. And it's the court's understanding that he has been accepted in Veterans Treatment Court. Is there anything else that you need to be successful? Probation, is there anything else?
Judge, I can't mention no visits.
Field visits, 1 time per month for 6 months. And of course, probation, once he's transferred to Veterans Treatment Court will set your conditions for you. So for example, I'm telling you that you need to be employed or full-time enrollment in school within 45 days. Veterans Treatment Court will evaluate you, and if Veteran Treatment Court does not think that's appropriate, then they will change that.
Yes, sir.
So the field visits, 1 time per month for 6 months, that's what I'm ordering. But once your probation is transferred to Veterans Treatment Court will handle all of your conditions. The only time you'll come back to this court is if they are saying that you're no longer appropriate for the program and they are asking that you be removed from the program, and they'll do that in the form of a motion to revoke. Do you understand?
Yes, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. I cannot stress to you how this could have turned out to be so differently. I don't know why people don't have patience anymore. I don't know why people speak to each other in such a negative way.
Yes, sir.
When accidents happen, they're called accidents for a reason, and that's why people have insurance.
Yes, sir.
All right?
Yes.
All right, my understanding, there's a victim impact.
Yes, sir.
All right. Why don't I have this file?
They're ready on this.
Oh, are you already on Joshua Mackey? Oh, I'm sorry. Did you all finish with the?
Ms. Abrams was writing some stuff down for the courts, so I think she's
Okay.
still doing.
All right, on Mackey, just give me a moment.
Yes,
You say you wanted to copy the dismissal you're on?
Well, no, I have the dismissal. I saw it in the system, but I need to sign the motion to withdraw.
Yes.
Okay. Yes.
Here's the motion. After looking at the allegations in the case that was dismissed, as well as her conditions from being originally placed on probation, I think that it would be, in Ms. Carrizales' best interest to get a little progress going on her probation. So we're in agreement to alter and amend to add, MRT, as well as for her to accomplish a parenting class within 60 days.
Okay.
That is correct.
And do y'all know, has she provided probation with drivers like a valid license and insurance?
To that, I'm not sure, Judge. I don't believe at this time she has one that's in compliance. I think it may still be suspended. But I will definitely relate to her that she cannot be operating a motor vehicle unless she has that. And then when she does get that, to get that to probation.
Okay.
Because the UMV, I know that stemmed the new number 1, which has since been dismissed. But I do understand the court's concern with her driving without a legitimate license.
And this is to complete parenting classes within 60 days?
Yes, she was originally placed on probation in 2021 and hasn't done anything. It's our understanding that she did go to TDC on a previous case, it kind of overlapped.
Okay.
So we're giving her a little credit for not being able to, but it has been a while, so we want to get her going.
All right. Thank you.
Thank you, Your Honor.
Yes. All right,
Give
thank
this to
you.
probation or the clerk? Your Honor?
Oh, just give it to probation.
Yeah.
All right, are you already on Mackey? All right, we're back on the record in 2014 CR 2014 CR 5495 State versus Joshua Mackey. If I could have parties re-announce, please.
Defendant for the state of Texas. And Kelly Fiddle for Joshua Mackey.
All right, and this is a continuation of the hearing that was started this morning. State, any witnesses?
Fortunately, it's not having markers.
All right, defense, any witnesses?
That's rest, Judge.
All right, the court has found violation of condition number 5 true. The court is going to find violation of condition number 1 not true. The court is going to find 15 FF not true. All right, any objection to the court reviewing the court summary?
None from the state. Can I see it?
And for the record, the court has not reviewed the court summary.
Can I remove the violation reports?
You'll have to speak with probation about it because that's their court summary.
I just don't, I have no problem with you speaking to the court summary, but not the violation reports since they're not. Okay, that's right. No objection, Judge.
Oh,
Oh, you have your own? Sorry.
No, I don't.
oh, okay, then, yeah, that's, yes.
All right, so what portion are you all asking me not to read?
I didn't realize that the violation reports are already in the court's file that you,
Yes.
that's taken judicial notice of, so no objection, Judge.
Okay.
And if we could just have time for a brief argument after.
Yes. Oh, and counsel, I don't have a trial court certification.
We'll get you one, Judge.
Okay. Oh, do you want to grab that while I read this?
Sure.
And state defense and Mr. Mackey, I see that there's a condition of number one in here. I previously said that that condition is not true.
Yes, Your Honor.
So I'm not going to consider that because I found it not true. And it's the same dimension of condition 15FF. I've also found that not true.
Thank you, Judge. Judge, can I present this to the court?
Yes.
I'll have it marked if you would leave it to. The state has waived this condition 10D, but I just wanted to bring it to the court's attention that the restitution is paid in full.
So was the restitution 36,000 or was it 44,775?
It was, what he owed was the 4,000 number.
Okay.
The total was the 36. The 4,000 was paid.
All right, the court has reviewed the court summary and the court has reviewed the document that the defense asked the court to review. State, what are you requesting?
Your Honor, you've taken judicial notice of the entire court file. You're aware of the facts of this case, the egregious nature of them, involving shooting the victim through the head, the right temple, exiting out the left side of her face. Very well could have killed her. Thank God it didn't. Otherwise, we'd be here on a different charge. So given the facts of the case, given that the defendant is on his second MTR since he had been placed on probation, and given the one true violation you found, Your Honor, state would ask for him to be revoked, adjudicated guilty, and sentenced to 10 years TDC.
All right, just one moment. I'm just trying to find in the court's file, I'm trying to find the admonishments page. Were you all able to see that, the admonishments page?
I don't recall, Judge.
If you could, and everyone, just one moment. Yes, thank you. All right, so as a part of your plea bargaining agreement that was entered into, the state was silent on your application. So I'll note that for the record.
Yes, Judge.
All right, defense, the state is asking for revocation. They're asking that your client be sentenced to 10 years in the prison. What are
Judge-
you requesting?
Judge, we're asking that you deny the MTR and terminate his probation. In regards to the facts of the original case, I believe I represented him at the time of his plea, and the complainant was okay with him getting probation. Judge Hilbig
gave him probation, gave him jail time as a condition. In between when Mr. Mackey committed his offense and when he pled, Mr. Mackey was shot in the head and almost died. That affected his brain functioning. He had a TBI and went through competency and was competent to stand trial. In regards to this being a second MTR, the state waived the first MTR, so it's not really something that the court we believe should consider. And we asked the court to reconsider that true finding. And the reason we asked that, Judge, is if you review those conditions of probation that are in the court's file, I've never had a contested MTR in which the state didn't either have the probation officer who read him those conditions testify that he signed those conditions, or number two, have someone, a fingerprint examiner, come in and testify that that thumbprint matches Mr. Mackey's thumbprint. The state has failed to prove that Mr. Mackey signed those conditions of probation, that he had knowledge of those conditions of probation, and therefore nothing could be found true because they haven't proved that he is the person who signed these conditions. In addition, what I testified to earlier and what Ms. Fuentes testified to was that there was no testimony or evidence presented by the state that Mr. Mackey knew to report to probation. There's nothing in those conditions that say, if this case gets transferred back to Bexar County, you must report to Bexar County probation. All it says is condition number 5 is report as directed to Bexar County. Well, we know that wasn't an actual condition of Mr. Mackey because he lived in Harris County. He was reporting to Harris County this entire time. Now, if the court still finds that it's true that he violated condition number 5, the court can do so, and we respect that. But we ask the court to review the totality of the case and that they have proven that he failed to report for 1 month out of 120 months. That's 0.8% of the time that they allege that he failed to report. And we ask that you consider what they've alleged and what they've proven and deny the MTR and release Mr. Mackey from this probation.
All right, the court is, as previously stated, the court is finding 5 true, 1 not true, 15 FF not true. The court will find the defendant guilty, grant the motion, revoke. There's an affirmative finding of deadly weapon. And I don't.
The admonishment from the secretary that you have already find it in this file.
Oh, the clerk printed it out. I couldn't find it either. I'm trying to see because I'm not the one who did the plea. The previous.
Are you looking for the plea bargain, Your Honor?
I have the plea bargain, but there are no mention of no contact or, I'm sorry, there are no mentions of any no contact orders. So
I have.
I'm sorry, Counsel, do you have the trial court certification?
I haven't had him sign it yet, Judge. I need to explain it to him.
Want to see?
Yes, please. Okay. All right, there should be no contact. There's to be no residing in any households with minors. And the court will sentence you to 6 years in the prison, give you credit for any time served. Is there anything else?
We ask for findings in fact and conclusions of law.
And have you gone over the trial court certification?
I have not, because
All right, if you'll go,
he needs time to understand it.
yes, okay. And then just come back and I'll finish.
I should have put something on the thing.
I'm sorry. Ah, thank you.
Thank you.
And criminal trial division, I don't know if this case is criminal trial division or family violence. But if you all could look over that and see if there are any objections. If you have objections, then we'll have a hearing. Is there anyone else on the docket? Yes. All right. All right, thank you. Yes, and that I'm assuming that travel permit, yes, yes, you may be excused. Well, no, because I still have to put this on the record. The trial court certification.
Yes.
All right. That had slipped my mind. Thank you. Mr. Mackey? You have a limited, I'm sorry, did you review the trial court certification of defendants' rights to appeal with your attorney? All right, did you understand it and sign it? I have to say yes or no for the record.
Yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what that is, you need to speak to the attorney. Do you understand? All right, good luck to you.
Thank you.
You're welcome.
Good.
Yes.
Before my client enters her plea, can I ask her a few questions on the record?
Yes.
Okay.
Yes.
No objection.
Oh.
Thank you.
All right, thank you. All right, thank you. Bye-bye. All right, are you all ready on Naomi Abba? If you'll come down, please. Court is calling 2025 CR 009075 State versus Naomi Virginia Alba. Can I have parties announced?
Lauren Espinoza for the state.
Martin Getter, attorney for Naomi Alba.
And are you Miss Alba?
Yes, ma'am.
And defense, there was something you wanted to be placed on the record?
Yes, Your Honor, if I may ask for a few questions.
Yes.
Ms. Alba, are you the same Naomi Alba that's currently on a 3-year parole?
Yes, sir.
And you understand that by entering a plea today, that could result in your parole being revoked?
Yes, sir.
Knowing that the parole could be revoked, do you still wish to enter a plea today on this case?
Yes, sir.
No other questions?
All right, counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Alba, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive the repeater enhancement.
Any objection?
No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with possession of a deadly weapon in a penal institution as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Alba, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
By entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State opposes your application for deferred adjudication. State recommends community supervision. They will take in consideration 2025 CC 009259. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor, state offers states exhibit 1 in all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, let's go on the record for a moment. All right, the court is going to find that there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Do you all wish to proceed or do you want a PSI? If you want a PSI, it's going to be about approximately probably 12 weeks.
Okay. Well, then we want to go forward. I don't know if you want to wait that long.
All right, then you're waiving PSI?
We'll wait PSI, Your Honor.
All right, the court will hear arguments against deferred.
Yes, Your Honor, state would urge that you deny the application for deferred based on criminal history. The most recent being an injury to an elderly person with bodily injury of January 9th, 2024, as well as multiple criminal trespasses, possession of marijuana, as well as evading arrest or detention. So that we don't see that she's fit for deferred at this time.
All right, and defense your argument for deferred?
Your Honor, aside from the fact that my client accepts responsibility, I think there are some genuine issues here that make this different from the typical case of someone taking a deadly weapon into a penal institution.
Mhm.
In this particular instance, what we have is that the officers brought her there, and then we have CERT officers taking her further into the facility. Yesterday, prosecutor was kind enough to help me get additional questions answered regarding the video inside the Sally Port and also inside the South Tower, because there's unfortunately not audio that's available, it's only video. But this is not a situation where she is a person who is intentionally trying to sneak a weapon into the facility. And in fact, she indicates that later on to the investigator from the sheriff's office when she was interviewed. Your Honor, this is, again, I have no problem asking for deferred adjudication in this particular case because if you look at the criminal history, it's all relatively minor. There is that one injury to elderly, and I will say that the knife that was seized was actually given to her from the person who was the subject of that previous injury to elderly case. She knows him, she's worked with him. He gave her that knife because he was concerned about her own safety because she walks quite a bit and she does so at night. And so again, this was something that was for her own protection. I just think that there's much to distinguish this from the typical case and that she does not pose a danger to the community and her relatively minor criminal history. I think all weigh in favor of her getting deferred adjudication, Your Honor.
All right, why didn't you just leave when he said he no longer wanted you there?
Ma'am, actually, he didn't tell me that himself. It was just the neighbor that actually I'm not sure the word, but he was kind of meddling into our business. I was there to cut the old man's toenails, as a matter of fact.
Mhm.
And I had fallen asleep on the couch, and the neighbor came in and he was meddling in our business, and he just started yelling at me. And then instead of yelling back at him, I just sat back down and I just kind of dozed off into my sleep. But the old
But no,
man,
they talked to the person there and he said he wanted you to leave and you wouldn't leave.
he never told me that, not once, ma'am.
Okay. So do you have any children?
Yes, ma'am.
And how old are they?
5 and 6 years old, ma'am.
And who do they stay with?
Their father.
When's the last time you had employment?
Well, I was self-employed, basically just working for that old man.
Okay. All right, this is what the court is going to do. The court is going to find you guilty. The court will sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. Take in consideration 2025 CC 009259. There's to be no contact with Jurgen Smith, JUERGEN SHMIDT. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, field visits 1 time per month until further notice, no unsupervised contact with minors, no residing in households with minors, 200 hours of community service restitution. The court will order parenting classes. Once that's completed, The community service hours will be deemed satisfied. Probation, is there anything else?
No,
Is there anything else that you need from the court to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you.
Thank you.
You have a good day. God
Oh,
bless you.
thank you. God bless you too. You're welcome.
I like your joke earlier.
Okay. Nora, we don't have